Hi, I'm Mathieu Lapointe, and I'm here with my colleague Jake Dwhytie. Jake and I are both chartered business evaluators and work in the forensics practice at PwC. This video is part of a series focused on litigation support. The topic for today is shareholder disputes. Jake, can you start by explaining in general what type of situations might lead to a shareholder dispute?
Broadly speaking, a shareholder dispute is a disagreement among shareholders which might relate to issues of corporate governance, the strategic direction of the business, or how the business's proceeds are being used by or dispersed among the various other shareholders. Most often, we see these types of cases brought by minority shareholders who naturally have less control over the business.
As CBVs, how do we provide assistance in shareholder disputes?
The main question that we are asked to analyze is what is the value of the business or the value of a set of shares in the business?
And that's an area we're pretty familiar with as CBVs.
Exactly right. As independent experts in valuation, we're experienced providing credible, in-depth technical analysis and communicating the complex calculations necessary to value a business in simple terms.
How does the CBV's involvement complement the work of the lawyers in the context of the dispute?
It's important to note that we don't formulate legal opinions in our valuation reports. When necessary, we rely on the parties' counsel to provide us clarification on the interpretation of legal clauses, and factors such as the valuation date or the definition of value to be used in a particular dispute. Those are also legal questions, which we'll usually discuss with counsel at the outset of our engagement.
Depending on the context of each shareholder dispute, the role of the CBV may differ. What are the different possibilities?
That's right. In some cases, we may be retained by one party or one side in a dispute. In other cases, the parties may decide to jointly retain an expert. A joint retainer may allow the parties to reduce some costs, but it does require us as CBVs to be more mindful of maintaining a transparent communication process to ensure that all relevant information is gathered and the parties' differing positions and assumptions are understood so that they can be incorporated and considered in arriving at our conclusions.
Let's talk a bit more about the types of analysis that we would perform in valuing a business for a shareholder dispute.
In valuing a business, the place we typically start is by looking at the shareholders' agreements and articles of incorporation to determine the rights and privileges associated with the various classes of shares. Those agreements might also include a formula for determining value, in which case we can assist with the interpretation of that formula and perform the necessary calculations.
In some cases, however, there isn't a shareholder agreement in effect for the business being valued. What other sources can be used to guide the valuation mandate?
In the absence of a shareholders' agreement, we may rely on provisions of the Canada Business Corporations Act or provincial equivalents, or refer to case law. Any legal interpretations will be discussed and validated with the lawyers involved. And once we have an understanding of the shares or assets to be valued, we select one or more valuation approaches. For example, we may use a discounted cash flow analysis as our primary valuation method and corroborate those findings by reference to public company EBITDA multiples or, say, multiples from comparable precedent transactions.
How do valuations in the context of shareholder disputes differ from valuations performed in other situations?
The analyses are very similar, but what might differ is where we focus our analysis and how we communicate our findings to the intended audience. Because in the adversarial context of a dispute, there might be multiple views as to the future prospects of the business. And our job as CBVs is to apply a forensic lens to the various forecast assumptions provided, challenging and corroborating those assumptions based on internal or external financial data as necessary.
In the context of differing forecasts or interpretations of particular issues by the parties, we often present calculations under various scenarios and express our conclusion as a range.
The purpose of providing multiple scenarios or expressing our conclusions as a range of values uh, is to help the parties and the trier of fact understand the impact that various key assumptions have on our valuation conclusions. This can facilitate settlement discussions, as well as more generally providing the parties with information as to the sensitivities of our calculations.
Every business is different, and some valuation analysis are more complex than others. How does the business valuation process account for this?
More than just providing a number, we set out our conclusions in a valuation report that communicates our understanding of the relevant background facts, the methodologies we've used, and the analysis performed, as well as documenting the assumptions that we've had to make in arriving at our conclusions. Our report may be submitted to the court or arbitration, and that's why it's important that all of the analysis that we've performed is set out in a form that is digestible by the trier of fact who may be less familiar with, say, interpreting the line items on a financial statement.
Finally, what are some key valuation issues which parties going through a shareholder dispute often need to consider?
Unlike valuation in some other contexts, valuation in a shareholder dispute may involve adjusting financial performance to eliminate the impact of some alleged financial harm. The conclusions could also be heavily impacted by minority or liquidity discounts, or it may be necessary to assess the extent to which there's personal goodwill in the business, just to name a few factors.
Thank you, Jake, for taking the time to share your experience.
Thank you. My pleasure.
This completes our quick overview of the CBV's involvement in shareholder disputes.